Well, hello, and today is November 2nd, 2018, and I'm here at the hallowed halls of justice. This is kind of like the Justice League with Wonder Woman and Superman and everything, except we're here at what's called the pre-hearings unit of the Division of Workers' Compensation, and I'm here with soon-to-be retired Judge Thomas D. Marino. And Judge, why don't you give what's your background, how long you've been doing this, and
Okay. I was admitted to the Colorado Bar by the Colorado Supreme Court on October 1, 1965 at 9 o'clock a.m. And I had my first workers' compensation hearing at 1 o'clock that afternoon. The name of the case was Parmley versus Viner Chevrolet and Maryland Casualty Company. And the issue was a strangulated hernia about which I knew nothing. And I said to my mentor who hired me, "Where do I find out about that?" And she said, "You do what we all do on medical questions. You go to the Denison Library of the University of Colorado Medical School and start reading the books about it." And so that was my first experience, and I've done workers' compensation cases from 1965 through 1988, and that's 33 years, and I've been a judge here in the pre-hearing and settlement conference unit from January 4, 1999 to now, so January 4, 2019 will be 20 years. I was appointed chief judge on November 1, 1999, and I served in that capacity for 13 and a half years, and was succeeded by Judge Jeffrey Goldstein. So I love this area of law, and it's complicated. It's gone from simple litigation to complex litigation. When I was admitted on October 1, 1965, a permanent total disability case was an award of $49 per week, and medical benefits were $500 or 6 months, whichever happened first, and that was the limit of medical benefits then. And so over the years, there's been a metamorphosis and of the law, a sea change in many years. 1975 was a sea change when the Colorado legislature ruled that there will be lifetime unlimited medical expenses. And I had the indignity to me, but dignity to the entire claimants bar of losing the case of Travelers versus Savio, which was a decision by the Colorado Supreme Court that made bad faith a tort action that could be pursued by injured workers, and later on the Colorado legislature increased the penalties per day for violation of any section of the act, and now both claims are viable because the legislature never ruled that one remedy took precedence over another. And in the course of settlement discussions, I have concluded that the claimant is the featured performer or participant of the settlement conference and should be included. And so at the beginning of each settlement conference, I ask the claimant, have you ever been in a settlement conference before? And in almost every case, the claimant will say, no, I've never been in one before. And I said, well, here's how it works. I don't know what the other judges do, but this is what I do. The structure of a settlement conference is exactly like the structure of a boxing match. It's comprised of rounds. And in round one, the claimant will give his offer of settlement in terms of money, and the respondent insurance carrier or self-insured employer will give its offer of settlement in terms of money, and that's the end of round one. With each round, after round one, the money that the claimant starts with as an offer of settlement will be reduced or go down with each round, and the amount of money that the respondent starts with will go up or be increased with each round. There's a point where the claimant cannot go down any further, and the respondent insurance carrier or self-insured employer cannot go up any higher. And I call that point an empty gas tank for each side. And I never know what that point is for either side before the settlement conference begins. So I need help from both sides. And each side has to tell me when they're one round away from an empty gas tank. They must say to me, our gas tank is getting empty. And the minute they say that, I tell the other side right away. If the claimant says it to me first, I tell the insurance company right away. And if the insurance company tells me first, I tell the claimant right away. And that's the first time I know in the settlement conference where things are heading. Until then, I don't know. In my cases, it generally takes 4 or 5 or 6 rounds before that event happens to one side or the other. Sometimes it goes faster than that, sometimes slower than that, but that's generally how it works. If the case is not settled, I emphasize to the claimant that he or she is entitled to a hearing. And at that hearing, nothing that was said in the settlement conference can be admitted into evidence at that hearing. So everyone is protected in a settlement conference. It's a legal secret. That means you can say whatever you want without any fear of it being used as evidence later at a hearing if the case does not settle. And that rule was invented by the Colorado Supreme Court on January 1, 1980, when it issued a thing called Colorado Rules of Evidence, and that's Colorado Rule of Evidence 408. There is a reason for everything, and if the case settlement conference results in a permanent total disability claim by the claimant, or the claimant expects to get permanent total disability, I like to inform the claimant that has become an onerous task, a large mountain to climb, because of what the Colorado legislature did in Senate Bill 218 on July 1, 1991, because On that date, they changed the law of permanent total disability qualifications, and that law has existed from then to now. Before 1991, permanent total disability awards were customarily awarded on the basis of a case called Gruntmeyer versus Temple and Escar, a Court of Appeals decision in 1986, and the opinion was written by Judge Louis Babcock. The attorney for the claimant in that case was John Gelhausen in the southeast part of Colorado, and Temple and Escar was a large agricultural employer in Lamar, and Mr. Gruntmeyer was feeding something through some machinery, including his right arm, and he was right-hand dominant, and his arm was severed at the shoulder, and they took him with his arm to Lahana Valley Hospital, where it was reattached, but it was a failure because it hung as a wasted arm at his side. And Temple and Escar loved the man and continued to employ him and paid him 50% of what he was paid before the injury. And they made jobs for him that were makeup jobs. And he answered a phone sometimes, and he did an errand sometimes, and he tried to sweep a floor sometimes, and then he had his hearing in his workers' compensation case, and the judge in that hearing awarded him 50% permanent partial disability because he was receiving 50% of what he earned before the injury. John Gelhausen, his lawyer, argued that it should be permanent total disability and appealed to the Colorado Court of Appeals. The decision at the Court of Appeals in favor of Mr. Gruntmeyer was written by Judge Louis Babcock, who was a citizen and of Colorado and grew up in the valley in southeast Colorado and knew everyone down there. He was a local boy, and he wrote an excellent opinion for the claimant in that case that ruled that if a worker could not earn more than 50% of what he earned at the time of his injury, then he would be entitled to consideration for a permanent total disability award. And he further ruled that makeup jobs were not a suitable gainful employment and would not count as jobs that a worker could perform. And that's how permanent total disability awards were awarded from 1986 to 1991. It's of note that Judge Babcock, who wrote that opinion for the Court of Appeals, resigned from the Court of Appeals to become a United States District Court judge, and he has been the chief judge at the United States District Court for the District of Colorado. He is now on senior judge status. And from 1991 to date, the labor unions have asked the Colorado legislature to throw out the law that they made in 1991, and they have not done it, and there is no good indicator of when they're going to do it. So that's the status of the law on permanent total disability.
But that standard now is you can't earn any wages, any job, any employer, anywhere.
That's right, and they made the standard so difficult that people sometimes have a good-humored smile or laugh at greeters at Walmart, but if they're on the payrolls and they get paid for doing what they're doing, then that's legitimate employment. And if a worker can qualify for that and is offered that kind of job, then that becomes employment that the worker can perform, regardless of what the comparison of that is to the money that he earned at the time he was injured. And that's just the status of the law at this point. So those are just a few comments that I would make about how these settlement conferences work and what the status of the law is.
So what do you recommend to people when they're about to go to or preparing for a settlement conference? I mean, what do you see that needs to be done that people maybe aren't doing or should be doing that's good?
All of these things that I mentioned should be explained to the claimant, and the claimant should be ready to talk about what his injury was and how it's affected him, because after I finish these discussions with the claimant, then I tell the claimant I'm ready as a settlement conference judge to ask him questions, and I want to know the claimant's answer to the date that he was born, the date that he was injured, what happened to him at the accident when it occurred, what parts of his body were hurt, how it has affected him, who are the doctors who have treated him, has any doctor who treated him said maximum medical improvement, and given a rating. And for that doctor, I also want to know what future medical maintenance the treating physician has said would apply in the future, and also what his work restrictions are. And at that point, then I need help from the attorneys on the procedural status of the case, on whether a final admission was filed, and if not, whether claimant has had the claimant examined by an independent medical examiner, whether anybody's asked for a division independent medical examination, which was created by the legislature on July 1, 1991 in Senate Bill 218, and that division independent medical examination is critically important because, and I explain to the claimant that opinion by the doctor on the issues of maximum medical improvement and permanent physical impairment can only be overcome by a clear and convincing evidence. And so the opinions of that doctor, the division independent medical examination doctor, referred to commonly as the DIME, will be used in an elevated status over the opinions of all other doctors on those two issues. And another issue that has been determined by the courts to be held at an elevated status when given by the DIME doctor is the opinion of causation. So it's an onerous task to overcome and throw out the opinion of a DIME doctor. And that figures and calculates into how much money the case is worth for settlement at this time. So these are all factors that make workers' compensation complex litigation, and it's really an onerous task for both sides to prepare properly for a settlement conference, because the whole case from each side's presentation is going to be on the table.
So, as you can probably tell, you did write the book on Colorado workers' compensation, right?
Yeah,
and
it
the
was
royalties are just
Colorado workers' compensation law and practice, and I was one of three authors. The other was Judge Janes, and Judge Janes before that was a director of the Department, not the Department of Labor, the Division of Workers' Compensation, and he approved the first permanent total disability settlement in the history of Colorado. When I presented that scenario to him with George Ashton, who was the attorney for the claimant, and we were all told that that would fail because you couldn't have settlements of workers' compensation cases because the state was a necessary party and would not participate in those. And Judge Janes, or Director Janes at that time, this was in the early 1970s, ruled that settlements could be done. We did, George Ashton and I, the first one, and it was approved by Director Janes. And that's what started all the settlements.
So now, when you retire at the end of this year, right?
Yes, I'm going to retire. My last day is January 31, 2019.
Okay.
And my first day of retirement is February 1.
Now, when's the party?
I hope somebody will think of that, but that's not my responsibility.
And then, so what's the plan in retirement?
I'm going to think about what I'm going to do, but one of the things I will continue to do is read advanced sheet opinions and stay up on the law because I love it.
You don't want to go back to litigation? You want a job? You
No.
you want a part-time job with us?
No, I think I'll just quit.
Well, I wanted to thank Judge DiMarino for giving that preamble and explanation of the work comp system, because I've heard it several times throughout the year. So I figured we might as well get it recorded for posterity. So thank you very much for listening to us, and thank you, Judge, for being here.
Thank you. Thank you for inviting me.